Every single thing that you say on the phone is recorded.
I know that, so why would I be on it threatening people?
We'll find out. I think that you are continuing to threat to the public even while being in jail.
I
don't want you to say anything. That's okay. We're going to find out because I'm going to have them pull all the records, pull all the phone calls, and we'll listen to everything.
Okay, but I can't call nobody. Literally nobody. So what? There's no TV in my tank. There's no nothing. What am I supposed to do?
All right, guys. Today we're stepping into Judge Flesh's courtroom, where 19-year-old defendant is facing multiple aggravated assault charges. Now, if that wasn't serious enough, he decided to make things even worse for himself by threatening the very witnesses tied to his case while sitting in jail. That's not just reckless, that's downright self-destructive. In this courtroom, Judge Flesher has zero patience for intimidation tactics. Yet instead of focusing on his defense, this teenager complains about not having a phone, no television, and acts as if his personal comfort matters more than the charges stacked against him. What he doesn't realize is that witness intimidation isn't just frowned upon. It's a separate criminal offense that can add years to his sentence. This moment serves as a reminder. The justice system takes protecting witnesses very seriously, and trying to scare them into silence will only dig a deeper hole.
Time to go play Fortnite. Let's go. Come on. Huh? Come on, man. I'm itching to go
approach, Judge.
Whatever happened with Mr. Wiggins?
Mr. Wiggins has some bond conditions to not speak to a complaining witness in an ag assault with a deadly weapon and an ag assault family member. He then went to jail and called her twice and her mom.
I mean, what more can we do? Really?
Take the phone away.
Oh, yeah, that's a good point. We'll do it now.
He also called not only under his own name, but he also called under 3 other inmates' names.
Good morning, Mr. Wiggins.
What?
How's jail?
Cool.
It's come to my attention that you are violating the conditions that we set out in this court, flaunting it, and trying to get a hold of the complaining witnesses in these cases where we've told you not to. Go ahead.
Yes, Judge. The deputy called me this morning and said that the defendant has called the complaining witness twice and the mother of the complaining witness as well. The deputy told me that while listening to these phone calls, he heard the defendant say things such as, "This is how you take care of things," and that everybody violates their bond conditions and talks to the complainants in these cases. He also heard the defendant make statements saying that he was going to continue to violate bond, and once he gets out, he was going to hire an attorney, but he had previously learned that the defendant was indigent, and so he took this to mean that the defendant was going to commit other criminal acts to get money to hire an attorney.
It honestly blows my mind. This young man isn't just intimidating witnesses, he's openly admitting to planning more crimes in the future. How reckless can you be? Instead of keeping his head down and preparing for trial, he practically hands the prosecution fresh ammunition to use against him. That's why I'm so interested to see Judge Flesh's reaction once the prosecutor lays out every detail. The judge already knows the stakes here, but this level of arrogance makes the situation even worse. It raises the question, what's the right response? Restrict his phone access, increase his bail, or add even tighter restrictions before trial? In reality, every word he says in court is sealing his own fate, and it's hard to watch someone throw away their future so casually.
The other courts as well, so that they know as well.
Yes, Judge. I just sent a full email to the felony prosecutor in case the deputy hadn't already alerted her. I just went ahead and did it. The deputy, again, is getting the transcripts for these calls, and that the defendant has been using 3 separate inmates' spin codes. That would be Jermaine Brown, Mark Diaz, and Dennis Compton.
Your privileges are hereby revoked. You are not allowed to use a jail phone at all from now on. Do you understand? I think that you are continuing to threat to the public even while being in jail. So your privileges to use the phones at all are hereby revoked.
Judge, I just, again.
She just told you.
Not even.
Please stop.
So
And I just want to reiterate.
Please, go ahead.
He's
Yeah.
19. You are taking away his ability to communicate with his family.
But he's
I
making
understand.
additional threats allegedly,
I
you know?
didn't threaten
Okay,
anybody.
we're going to get the records, but
Okay.
until I know that you're not a threat, I mean,
He's typing everything.
every single thing that you say on the phone is recorded.
I know that. So why would I be on it threatening people?
We'll find out because I'm going to ask, could you mind please pulling all the records, getting all the phone calls, and we'll play them out here in court and we'll see. And if it's not, then I will gladly give you your phone privileges back. But there have deputies that have pinpointed you allegedly, you and using other people's spin numbers to make phone calls, to make continuing threats, and to further criminality if and when you get out.
Now, let's talk about the defense attorney, because I don't envy her position one bit. She's standing there, clearly aware her client is in serious trouble, yet she's obligated to present something in his favor. Her main point? That is only 19, and he needs contact with his family. On the surface, that sounds sympathetic, but when you weigh it against threats, gang ties, and violent charges, it just doesn't hold up. By 19, you are fully capable of understanding the difference between right and wrong. Courts don't excuse threatening behavior simply because of age. In fact, being young doesn't soften the consequences. It just shows how early this defendant is walking down a dangerous path. Watching the defense try to build an argument here feels like trying to hold water in your hands. It's bound to slip away.
What?
Well, I don't want you to say anything. That's okay. We're going to find out because I'm going to have them pull all the records, pull all the phone calls, and we'll listen to everything.
Judge, I will also say that the defendant told the complaining witness, this is about the ag assault involving the firearm, that when she got shot, the defendant said that's what happens when you hang out with gangsters.
So pull all that stuff, you know, and all that stuff gets, so we need to figure out how, because it's a first for me as far as doing a revocation of privileges like that. As far as revoking phone privileges for inmates,
As far as I know, it has to be through the court order.
okay. I need to do whatever I can because it's apparently a problem now. So, I guess I'll reach out to administration as well to figure out how, because I mean, it's a first for me.
Judge, just so we're all on the same page, Mr. Wiggins is obviously going back to the jail now. Even before that order is in place, you are instructing him now not to use the phone. So,
Oh.
So I did do it. That's so stupid.
well, we'll get the tapes and
Get it? We'll
Okay,
see.
look, okay, but I can't call nobody. Literally nobody. So what? There's no TV in my tank. There's no nothing. What am I supposed to do?
It's jail.
What's the point?
Read a book.
There is no books. I read every book in there.
Yes.
Okay. I can't trust you to use a phone, Mr. Wiggins. I mean, you know what's happening. I have other deputies that have alerted us to what's going on. I can't. That's it. I mean, you got to know when you're in the jail, there are eyes all over you. It's like at a casino. You literally have eyes all over you at all times. You got to know that whatever you're doing is always being looked at.
Stay in bed. That's why I wasn't threatening nobody. I didn't say
he's
anything.
typing
and
everything
then-
you're saying.
Asking them
I
to pull it.
understand he's talking about I'm doing illegal things when I get out to hire a lawyer and all these other things. That's stupid. I never said anything about anything illegal. That's just
So here's the big question. Was Judge Fletcher too lenient, or was there really no other option in this situation? Taking away the phone certainly stops immediate witness threats, but does it fix the larger issue of reckless behavior? Not really. A pattern is already forming. Multiple assault charges, ties to dangerous groups, and now intimidation from behind bars. The truth is, the law treats this kind of conduct as extremely serious. Witness intimidation can stack years on top of existing charges, and judges know it undermines the entire justice process. At this rate, the defendant isn't just risking a longer sentence. He's setting himself up for a life defined by prison walls. The question now is whether he'll realize the severity of his choices, or whether he's already too far gone. What do you think? Does this young man have any chance of turning things around? Or is he locked into a future that only gets worse from here?